time set for oral argument in our case captioned Tammy Felipe and others versus Theme Tech and Mr. Sandoval. And our cause number 1CACV130393. And we have allotted 20 minutes aside. If more than one attorney is going to argue for either side, then you need to divide up your time and let us know. If that's not an issue, then we won't worry about it. We have reviewed the case. We've thought about the issues. We're interested in what is meant in Rule 26B4D by one independent expert. We're interested in your other issues as well, although at least one of us here who's talking thinks that's probably the main issue. And if you would, as usual, identify yourselves for our recording when you come to the podium to argue. And if Appellant's Counsel wants to reserve time for rebuttal, you may do so, as you know, and we'll try to honor that if you want to reserve some time. Having said all that, please proceed. Okay. Are you referring to Mr. Worth's additional opinions that he didn't get to render, or Mr. Black's testimony, or all of the above?
Why do you think the word independent was chosen in the rule as opposed to retained? The two are hardly synonymous.
I think independent could mean that, but as between each side's retained experts and Officer Garcia, wouldn't he, almost by definition, be the most independent? But he was there apparently to reconstruct speeds.
And our expert disagreed.
Why then did the plaintiffs draw the speed opinions from Officer Garcia? Why not simply draw from him the foundational information, the measurements, the observations, the crush of the trucks, the debris on the road, photographs, etc.?
They were discussing the speeds for accuracy in terms of his report, but also to contrast information basis to dispute their experts. In other words, Officer Garcia was going to talk about speeds, not there. Our expert was actually
So you view the plaintiffs as sort of setting up, using Officer Garcia as a straw man to knock down?
I think it was foundational in the circumstance, and also to talk about
Accepting for a moment, though, that the two witnesses aren't cumulative, we're still left with the language of the rule. And maybe I'm just misperceiving the meaning of independent, because I can think of few people less independent than a retained expert in almost any circumstance. But once you have testimony, expert testimony on an issue, how do we reconcile the actual language that the rulemakers used with your position?
I think you're referring, excuse me for interrupting, but I want to make sure, I think you're referring primarily now to the 1991 committee comment. Isn't there a special rule for medical malpractice cases that you're, and we don't have that here?
We don't, but we have other cases that are not.
I mean, the ADOR case and the Frankovich case? I should remember Felder, but...
But of course, Officer Garcia here had no relationship to any party.
Yeah, most of the time, most of the City of Phoenix police officers aren't expert reconstructionists, but Officer Garcia is.
To a certain degree, if you look carefully at what he said, it's accident reconstruction training. It's experience. And I actually think that most police officers, particularly in substantial accidents and absence of they have to decide whether the patient's
But are you saying then that Officer Garcia is really no different from any other more or less experienced police officer?
Fact witness is allowed to give his opinions and the things that does not
He may be an expert on those occasions where he renders an opinion that's based on scientific analysis. But you're saying is he shouldn't be counted as an independent expert for one side.
one side or the other.
So-
Only when the opinions of the it's treated
But excuse me for interrupting, but from kind of a big picture point of view on this issue, you're asking us to say, in essence, that one independent expert in 26B4D means one retained expert per side, per issue.
When could it be different? You know, if that's what the rule means, isn't that what the rule means for every case?
I'm not sure when it would be different. Maybe I
So somebody wants to call two police officers to express opinions.
think that might be problematic. They certainly did list him as a controlling factor and their expert witness, so that's his. All of Mr. Worrell's They went at him to say, you didn't run your analysis based on this. And in fact, they made a motion. Something different based on those different speeds. So I understand that ultimately said.
Just keeping an eye on your clock and understanding you want to reserve some time. Do you want to address cell phones for a moment?
It's troubling to me because again, that beginning of this case, during motion practice, cell phone, whether it was on the cell phone or icons, is the crucial issue in this case. Why was he distracted? What happened here?
Well, is it that you were precluded from putting evidence that he was on his cell phone, or that you were precluded from putting on the human factors expert?
it seems to me that one of your problems here, that may have prompted Judge Gama's ruling, is that you're using the expert to conclude, and apparently to the exclusion of other explanations, such as he was just daydreaming or thinking and maybe not paying close enough attention or something like that, but to conclude that in spite of those possibilities that he wasn't using his cell phone, and then to render, that he was using his cell phone, and then to render opinions is kind of using the expert to bootstrap the evidence that he's then going to use to render opinions upon.
What kind of cell phone was this, by the way? Was it a smartphone or was it just a phone? Okay. So basically, if you're using it, you're either talking, listening to voicemail, or texting. Or okay.
What was, remember, Judge Gama here, when circumstantial evidence means that cell phone records were either searched no definitive witness.
Conflicting testimony, you're not suggesting there's somebody who said that he was on his phone.
I think what they're going to tell you is his mom was on his phone and she saw him after. First, that doesn't cover. Was he getting it out in the process to call his dad to let him know he was on the phone? The evidence shouldn't be on the job once. There's no evidence of, in fact, he's very blunt. He says, I never saw him. There's no evasive action. And you can go through that why the cell phone expert would testify why reaction is reduced by 18%, why your perception is reduced by so much, why that's so important is the education section. The argument was, in the trial court law, is that we all know it's bad to be person. We all assume it's responsible. We don't want a jury without quantification of what that really does to you, how that really harms yourself, allows the jury to just go, no, it's bad. I think that this expert was going beyond. I don't think the average person knows what they're doing with a cell phone. That does to push down further on your pedal inadvertently and speed inadvertently. That one explanation. It's important to allow us to listen to circumstantial. They could have used their own arguments that they act very effectively made without us to
Thank you. Mr. Doyle.
William Doyle, Doyle firm on behalf of both defendants below.
Thank you.
I would like, similar to Ms. Fedahar, I'm going to focus my attention on the expert issues. I'm happy to address any questions. There is nothing in statute that requires an investigating officer to reconstruct the collision. That is an entirely different proposition.
So why does Officer Garcia do it?
He does it because he has been trained to do so, and he is doing it in an effort to determine whether any citation should be given. He is not prepared to do it. The citation could have been given based upon the factual investigation. He decided to use his specialized training, which was not based exclusively on his CI experience in investigating accidents.
But it doesn't really matter, does it? I mean, knowledge, training, or experience is good enough. Whether he had a PhD or just a lot of on-the-job experience, it's all the same thing. Yeah.
My point is not whether Officer Garcia was actually qualified. My point is to suggest, as the plaintiffs below act, that they should be entitled to elicit opinions from Officer Garcia and then call a, quote, independent expert who they retained, because Officer Garcia had the obligation to reconstruct under the statute. He is not.
Well, let's talk about the interpretation of the rule for a moment. I mean, I talked with appellants about the word independent being somewhat inartful, and it doesn't really describe any trial scenario that I can think of. Experts don't loiter around the courthouse waiting to testify independently. When you pay them, they're anything but. But what I'm concerned about is that your reading of the rule would make the word independent entirely superfluous, because you seem to read the rule to simply say one expert. So why say independent at all?
Our circumstances there's someone who may give expert testimony as an employee, for example.
It's the ADOR case, I think.
And so the concept of independent expert is independent of parties.
Well, not to be trite, but aren't law enforcement officers sort of all of our employees?
There were two parties to this case. What's at issue in this case is not whether or not there was some criminal conduct.
No, but when you're performing a public function, aren't you performing that public function on behalf of the public generally?
Yes, you are. That public function is not to the benefit of the plaintiff exclusively, which is what they want. It is to the benefit of all of us. And so the idea that you are only entitled presumptively to one independent expert, and that is an independent expert who is not undertaking an action which is for the benefit of a particular party.
Well, what else do retained experts do? I mean, that's their purpose.
The word independent in that rule is
Weird.
weird would be one way to put it, because they're never independent. We know that.
Right.
All right, and we don't contest that issue. What we contest is the idea that you can call a police officer. There's no other reason to have called him other than to elicit this testimony. Because if the suggestion is, well, I'm laying the foundation for my expert, the police report was already in. It's 270 pages long. It was in evidence. So you can't call this witness and elicit specific opinions from him and then suggest that I am then entitled to call a second witness who I have paid to give additional opinions on the same issue.
So is it your contention then that both Officer Garcia and the retained expert are independent experts? They're each independent experts?
As it relates to the opinions that were elicited from
That they're both independent?
as that term is used under the
So unless the plaintiff is lucky enough to have an accident reconstructionist on his or her personal staff, every expert in a case like this is an independent expert. Do you think that's what the court meant when it passed the rule? Shouldn't that be important to us?
In fact, and maybe I'm misunderstanding the court's question. I do not believe that they are both independent experts in the context of the rule. The position we take is that by eliciting the opinions of the police officer, the party who elicits those opinions, to the extent they are on issues which they then call their quote independent expert under the rule.
Well, that would just be an argument that it's cumulative. But if you acknowledge that they're not both independent experts for purposes of the rule, then by definition, at most, plaintiffs could have only had one. I mean, it could have been Garcia or it could have been their retained expert, but it wouldn't have been two. But then, well, maybe I'm not being clear. But if only one of them is independent, does it matter which one it is? Because at that point, aren't plaintiffs allowed to call both?
The idea that one is independent is a concept which doesn't equate to the retained expert, frankly. And so the idea of independent is independent of, as I said earlier, what an employee of a particular party might do. And so therefore, once you call Garcia and elicit opinions as it relates to those issues, you have in effect presented an independent expert in the rule.
Okay, but then the retained expert is essentially an employee of the party.
Well, no, it's an employee of the attorney for the party.
Maybe, if the party has an attorney, but the retained expert is being paid. I hate to be too cynical, but being paid to say what the party who retains that expert wants them to say, or else they're not going to call them.
Ultimately, what's going on here is that the plaintiff alone is telling you we didn't get to put on the opinion we paid for. And the reason we didn't is because we elicited an opinion on the same issue.
Does it matter whether the opinions are the same or whether they're different?
It does not matter. And in this case, there was some difference.
What do you suggest we do with the committee comment which says, and I'll get it out here so I can quote it, the words independent expert in quotes in this rule refer to a person who will offer opinion evidence who is retained for testimonial purposes and who is not a witness to the facts giving rise to the action. Do we just ignore that comment? If we are to give it weight, it tells us what independent means in this context, and applying it here, Officer Garcia would not be an independent expert as defined here because he was not retained.
He was not retained. In order to keep the comment retained, it's inconsistent with the concept of independent expert. Secondly, the rule, beyond the comment noted by the court, the rule presumes you get one expert per issue.
Well, I know a lot of us over the years have talked about this as a one expert rule, but it's actually a one independent expert rule. So what does independent mean?
Independent means, as I said earlier, someone who is not employed by a party to undertake conduct as part of their employment. That is the concept of the cases cited by the appellant.
But again, it can't really mean that, can it? Because our most cases involving retained experts, and aren't retained experts employed to do just that?
Well, yes and no. There are lots of cases in which a party has employees whose position in a risk department, for example.
Not a personal injury plaintiff. I can't imagine that there's any person in this country who employs their own accident reconstructionist on a regular basis as an individual.
But in cases cited by the appellant, they are not. One was the state of Arizona, as I recall. What if the defendant is a trucking company whose risk department has a number of work responsibilities?
Right, but we want the rule to apply equally to plaintiffs and defendants, don't we?
It does. That's why didn't ultimately give the opinions he held on all of the issues that Officer Garcia didn't testify to. And in fact, Mr. Worth ended up testifying as to the ultimate opinions he intended to give based both on what Officer Garcia had said and by, with due respect, backdooring his own opinions about speed and causation.
I mean, when he testified that Officer Garcia's speed estimate of the defendant, Isuzu, was low, is that what you're referring to?
Yes.
Yeah, but he didn't get to say 38 to 42. Shouldn't he have been able to?
You certainly should have. If they hadn't gone ahead and listed that opinion from Officer Garcia. This was a voluntary eliciting of the opinion. No one stopped them, and in fact, as I recall, and I've not looked back at that portion of the transcript, they were warned about it.
I think my understanding is that the warning that you referring to that came from the sidebar discussion was after those speeds had already been elicited.
But nonetheless, it was a voluntarily elicited opinion. Switching to, unless there are any more questions on the switching to Mr. Black. There must be, this court knows, an actual predicate to base an opinion to be admissible at trial.
Is it not enough that your driver client did not react, did not hit his brakes, did not know for sure whether he had seen the blazer or not? Isn't that enough?
Not without the additional factual predicate to suggest that the reason for that was cell phone use. And here's why there was no factual predicate. The testimony of Ms. Baca was uncontested that she did not contact 911, initiate contact with 911 for 1 minute after the collision occurred. That was uncontested. Taking that into account and looking at the cell phone records and 911 records, it would not have been possible for Mr. Sandoval to have been on the cell phone at the time the accident happened or before.
Assuming everybody's clocks are synchronized when they keep records.
Cell phone company's digital and 911's digital.
I can think of a lot of computers on a lot of desks in this building that are digital, but they're far from synchronized. In fact, they don't work half the time. I mean, and I'm not being facetious. There really is a difference between being accurate and being synchronized. You can have a wonderful Rolex that's set to the wrong time.
Of course.
And so we don't have any evidence that these clocks were synchronized. I guess, but the question that concerns me, and I need to go back and review the expert disclosure, is whether Mr. Black was proffered for the purposes of showing how bad it is to use cell phones, or to show that there was cell phone use at the time. And your opponent seems to suggest it was the latter in addition to the former.
In fact, Mr. Black was proffered with reasons for to get on the cell phone at the time for the collision.
So then isn't the exclusion of Mr. Black merely a judicial comment on his credibility rather than the foundation for his report?
No, it's exactly the opposite. In the absence of a factual predicate for that opinion, what the court determined was that opinion would be pure speculation, which it was. There has to be some factual basis for the opinion. There was none here. If in fact, again, back to Ms. Baca, maybe the clocks aren't synchronized. It is the plaintiff's burden to establish they're not, and therefore contest the testimony of Ms. Baca and create an inference that he could have been on the phone based upon the timing of the call. They didn't do that. They didn't offer Mr. Black to say there are a variety of reasons one isn't paying attention. As the court pointed out earlier, I'm daydreaming, I'm listening to the radio, I'm doing all sorts of things, which may be negligent in the context of these circumstances that have nothing to do with the cell phone. Mr. Black wasn't going to say that. What he was going to say was that Ron Sandoval was on the cell phone and using the cell phone prior to the accident. There was no factual basis for that. It's the court's obligation to ferret that out and determine whether there is any basis so it isn't speculative opinion. as to the inference that he was on the phone, they were allowed to present that evidence and argue it. But you gotta have some basis to let the opinion in.
Well, it seems to me there's a possible disconnect here. If they were allowed to argue it, that would, I gather that means that the jury would have been allowed to conclude it. And if the jury was allowed to conclude it, then why wasn't Mr. Black allowed to explain what the significance of cell phone use, including reaching for, starting to dial, etc., as well as being on, might have been?
And because it would be purely speculative.
Do you,
Some basis for him to reach the conclusion. It's what you were describing earlier. But what they tried to do was bootstrap the evidence of cell phone usage through the expert by saying, in my opinion, he's on the phone or using the phone, and so therefore, because he's using the phone, here's all the consequences of that.
well, and that may be a valid criticism of the opinion, good for cross-examination. But let's assume that the court let the expert testify. Would that have been an abuse of discretion? Would that have been appealable, reversible error to let him testify?
He testified as to what was in the report specifically. You might be here with me on the other side, suggesting that there was no basis to allow the opinion and unduly influence the jury. It might be.
Well, and I might agree with you that I might well agree with you that just saying, there's a possibility he was on the cell phone, let me talk to you for 4 hours about how bad cell phone usage is, could be unduly prejudicial. But if the court had tailored its order on the motion in limine to allow the presentation to be geared toward whether he was on the cell phone, how could that have been reversible error? Isn't that pretty critical information? Yes. In other words, the court could very easily have said, Mr. Black can testify as to the reasons he thinks this defendant was on the cell phone. He can't go off on a diatribe about how bad cell phone use is until I determine that there's enough there for the jury to conclude that he could have been on the cell phone.
I think that's what the allowed to go into diatribe, despite the absence of underlying evidence. If the reverse had been true, and Judge Gama had let Mr. Black testify, he might have been on the cell phone. This is all the bad things that happened on the cell phone. Would I be appealing that ruling? Maybe. But remember, that's not what Mr. Black was going to say. What Mr. Black was going to say was he was on the phone. And there's a significant difference between that and he might have been, and if he was, because what that's doing is testifying as to an issue for which there was no factual predicate.
Was he going to assume that he was on the phone, or was he going to testify as to the reasons he believes he was on the phone, however flawed those reasons may be? Because?
For all of the reasons we talked about,
Because he was driving badly.
I take the plaintiff's position because he could have seen the blazer 600 feet away and didn't do anything, and Miss Pocket did something.
So is the essence of it that if you're driving badly, you must be on the phone? Okay.
That's the speculative nature of it.
Okay.
We're going to add about 2 more minutes to each side, if you would, Alejandro, please. Because I have a few more questions for Mr. Doyle. We'll go back to the other subject. Then we'll add appellants 2 minutes when the time comes. Oh, we'll do it right now. Okay, good. Go ahead. Okay. Okay. To go back to the one expert or one independent expert per side, per issue rule. Had you listed Officer Garcia as your expert? And did that witness testify? But you must have made some listing that the plaintiffs are talking about in terms of listing, perhaps a blanket listing of officers and something like that.
We listed all of the officers who are mentioned in the and that included officers.
Now, I wasn't entirely sure I was following your argument about Detective Loeffler. Let me make sure factually that I understand. Detective Loeffler are you saying that he was responsible under the statute? And I'm not sure I understand why Officer Garcia was not also responsible under the statute.
Well, Officer Garcia certainly may have some statutory obligations. But the plaintiff's position, part, is to what it should work in addition to the opinion of Officer Garcia, was that Garcia formulated his opinions as part of his public obligation to investigate the collision and report on it. My point was that if we look at the statute and how this investigation was conducted, that it was Detective Loeffler who would have had that obligation under the statute. He is who was in charge of the investigation, and he is who signed the report, prepared it and signed it. His report may have included portions by other officers involved in the investigation, of which Officer Garcia was one.
Who did the reconstruction of the speeds?
Officer Garcia did that portion. But that was not a statutory obligation at this point.
How do you know that? Upon what do you base that?
The statute says we have to investigate. It doesn't say, and there's a distinction, significant distinction between investigation and reconstruction.
Yes.
And the statute doesn't require a reconstruction by the police, it requires an investigation. And
Why is this important?
they want to suggest to you that Officer Garcia's opinion was part of his duties, and in the same context as the medical examiner in the Frankenwich case, I believe, that he had an obligation to do it and therefore wasn't an independent expert under the rule. And in fact, that's not true. He did it, and he did it as part of the investigation, but it is not required as part of the investigation.
But he didn't do it in any capacity other than as a City of Phoenix police officer.
Absolutely, he did not.
Okay. Anything else for Mr. Doyle?
Thank you.
Thank you. Okay, our clock says 2, but I think we'll give you about 2.5.
That's hardly novel. I mean, is his opinion really going towards some special knowledge he has about cell phone use, or is he just saying if you're driving badly, that would be consistent with cell phone use? Of course, it would also be consistent with being drunk or any number of things. So is this just an expert comment on the credibility of a witness?
No, I think what he's looking at is physical evidence, physical
And I don't want to take away the rest of your time. So.
No, and Ms. Baca was uncontested, was contested. And we talked her through very specifically where she was and what her perceptions were and why her time was. In fact, made much of that she was calling in time after she looked at
Do you think that our appellate review of Judge Gama's motion in limine excluding the testimony of Mr. Black is based on what was before the court at that time, or based on facts that may have changed a little bit by the time trial was over? Why? Don't we have to do it based on what he had in front of him?
I think you sufficiently
So it wasn't just one ruling then, it was multiple rulings.
And it would revisit it, which is how we got to the summary. For example, on page 47 of the statement, Mr. Knotts said that he was going to call Detective Garcia as an accident and instructions. As listed, we cited you the record cited. And yet he got to put on an additional accident instructions that helped support Officer Garcia.
Did you make a one expert objection?
Yes, we did. I believe we did. I believe it was complete for the record until we had, unfortunately, the technical drama beyond. Felder is not a medical case. Arizona Department of Revenue case. Neither is but it is pretty cool, so I won't disclose that. But I think the Arizona Department of Revenue case has to what is
And we are at the end of our time.
I'm sorry.
That's all right. Thank you both very much. Obviously, we're interested in the issues, and we appreciate both your arguments, and we'll take it under advisement. Thank you.